Hi, I'm Irene from the Saving Wrentham and Hogan Alliance. I want to say a few words about the hearing that I went to at the Massachusetts State House before the Committee on Children, Families, and Persons with Disabilities. This hearing occurred last Tuesday, September 9th, 2025, and I went there because I wanted to talk about some problems with supported decision making. But I want to talk about some of the other things that also happened at the hearing. A wide variety of bills were discussed, not just supported decision making. There was a bill H-256, an act requiring universal changing stations in public buildings. This bill would help families with children or with adults who need diaper changes. There was also H-282 S-168, Tommy's Law, an act to increase the safety of individuals with disabilities relying on life support equipment. I believe that both of these bills are worthy of support and consideration. Then there was H-242 S-149, an act to enhance standards of care for those with autism and intellectual and developmental disabilities. While the intent of this bill is noble, I believe it lacks practicality. How expensive would it be to train every healthcare professional how to diagnose and treat the broad category of autism and intellectual disabilities? And when I say that, what I mean is autism, if somebody has autism or an intellectual disability, that affects any diagnosis and any treatment that they might have for any other comorbid conditions. So it's not about actually treating the autism and intellectual disabilities. It's about treating every other health problem for this category of people. So as many of you know, I'm a proponent of making IDD care a specialty, just like geriatrics and pediatrics. Also, training for healthcare professionals should use a see one, do one, teach one approach common in medical circles. Didactic lectures may convey knowledge, but they don't develop the motor skills or clinical judgment needed in real-time patient care. The see one, do one, teach one model forces learners to synthesize theory with action, often under supervision. This is a form of apprenticeship that is deeply embedded in medical culture. That is why the Saving Wrentham and Hogan Alliance is advocating for a teaching facility on the Wrentham campus. That would be a far less expensive and more effective approach. So let's get back to the hearing. Then we heard about Resolve S-128. This effort establishes a special commission to comprehensively examine DDS regulations and practices. This was referred to committee as of February 27, 2025. It's still in the legislative process, and appointments to the commission haven't been finalized. The timeline calls for members to be appointed by December 31st, 2025, with a report due December 31st, 2026. The commission includes the ADDP, the Association of Developmental Disabilities Providers, a lobbying group for corporate providers. Number 2, the ARC of Massachusetts, which also operates services and serves as a corporate provider. The Providers Council, even more corporate providers. With Resolve S-128, there's no guaranteed seats for family advocates or guardians. There is no guarantee that individuals with severe or profound needs will be represented. And one of the things that I keep on hearing from families is that our system is provider-centric, not centered around the individual with the disabilities. And this is how you get that, by having corporate providers represented and not the actual individuals. Okay, so regarding H261, S155, supported decision making, several self-advocates, representatives of the corporate providers, and representatives of organizations advocating for supported decision making testified at the hearing. Only David Castle from the Coalition of Families and Advocates and I testified opposing this bill. I testified on behalf of the National Council on Severe Autism. Oh, and by the way, we're not exactly opposed to it. What we want is we want amendments to it to protect those who have severe and profound autism. That, with certain amendments, maybe the bill could be passable. And the NCSA is one of the Saving Wrentham and Hogan supporting organizations. The committee made us testify dead last. We had to listen to everybody else first. And of course, my testimony got cut off. Mina Murray from our board of directors also attended to provide moral support to David and me. We all sat together, and all of the organizations have been working very closely together on these issues, especially COFAR and the Saving Wrentham and Hogan Alliance. At the hearing, it was clear from Attorney Rick Glassman's testimony that the intent of the advocates of supported decision making is to make SDM the default. In other words, families would have the additional burden of proving that supported decision making is insufficient in order to obtain guardianship. And of course, that means higher legal costs for severe and profound families, because obviously the lawyers are not going to be, doing this additional burden of proof for free. You're going to have to pay for that. So at the hearing, this burden of proof, this is what Dave Castle made this the centerpiece of his testimony. COFAR has long opposed the supported decision-making legislation and was the first to report on and analyze this year's bill. Our population is such that it's very difficult for most of our families to spend an afternoon at a hearing. However, you may submit testimony. We need everyone's voices, and I am going to leave the email addresses to whom you can send your testimony to in the description below. Thank you for listening to my video, and I'll see you on the next one.